Good afternoon, everybody. Welcome to another Focus Tech School. So we're grateful for everybody who's come on to participate. We have Larry here today, who's going to be talking on the topic related to intellectual property. So I'm super excited about it. It's the topic headline was "Who's using your intellectual properties," which is a little bit different than a normal conversation about IP. So I'm excited to hear a little bit more about how that about that. I'll let Stephen kind of do a quick reminder for those who are joining us on YouTube.
Awesome. Thanks, Sam. Yeah, so we got an awesome speaker today, and like Sam mentioned, we got Larry coming on. He's going to talk a little bit about intellectual property, specifically who's using your intellectual properties. And there's a reason that we have that title, and he'll go into it. But I know we're excited. It's kind of a big topic that comes about a lot with startups, small businesses, and just ventures in general. So it's pretty great. If you guys have questions or anything during the talk, while Larry is speaking, or even afterwards, feel free to leave them in the chat, or just let us know in the chat that you have a question, and we'll try to get to it in real time and pop in. If you're on the Zoom call, we can just hand it over to you to ask the question in person, and if you're on YouTube, then we can ask it on behalf of you as well. So wanted to say that. And then if you are watching this on YouTube, feel free to like, comment, subscribe, all that fun stuff. All the interactions we get with videos like this increase our reach. So they allow the video to reach more people. And so that like or comment that you leave might push this video out to somebody who really needed to know a little bit about intellectual property, or had a question that Larry was able to answer today. So if you have a chance, feel free to do that. But I'll hand it over to Larry.
Well, thank you very much, Stephen. The reason that I used the title was that, properties, there are several intellectual properties, and everyone owns intellectual property. I don't care whether you believe it or not, or you simply do. So everyone owns and uses intellectual property, which we commonly refer to as IP, and that's patents, trademarks, copyrights, and trade secrets. There's a few others in there, but they're not as important. Examples of trademarks, Exxon, Coca-Cola, Apple, Google, Fokcus. And service marks are such as Sprouts, Sears Roebuck, McDonald's. Those are service marks, or they provide services under those marks. Also, some trademarks involved there too. Trademarks have to do with marks used in trade, and service marks have to do with services used in interstate commerce. It doesn't have to be, it can be a service mark that's local. Copyright examples, everything that you reduce to reduce to being able to be seen, basically, is a copyright that you own from the moment you create it. You don't have to register anything to own it. That's important. So you write a letter to your grandmother, you already own the copyright in your creation, which is your expression of what you wrote. And so literally everything that you do that is other than you standing there looking out at the sun, you own the copyright in. You take a picture, you own the copyright in the picture. And then the question is whether to register it. That's another question. Now, in inventions, you probably don't need much to define. Those are things that are useful. Copyright are things that are creative but not useful in the sense of a thing which does something. Now, if you own a book, you can make it useful by using it as a doorstop, but that's not what's thought of in the usefulness aspect. Trade secrets are an extremely important part of intellectual property, and that has to do with the business knowledge used by a business that they maintain in a confidential status. Only a person or two or three would actually be aware of. It has to be treated as a secret of the business. So in other words, it can't be on an open floor where people come walking through as they are touring the plant. It's got to be in a locked room, in a sense, whatever it might be. but it could be customer lists, supplier lists, various kinds of things that give a company an advantage in their trade or business. So that's what the trade secrets are. Now, by the way, I just wanted to warn you that you be sure to tune up your listening speed, because I speak at about 100 words a minute with gusts up to 125. So I want to get through this as rapidly as possible. So it's interesting that in 180 years that we've had a patent system, we have over 9.6 million patents issued. That's a lot, but they're coming much faster and faster and faster as the clock continues and people are inventing. And of course, there's more and more people in the world. And so if you invent at the same rate, in other words, 1 patent per 100,000 people, well, you just keep increasing the people and you get more patents. More than 6,000 trademarks have been registered in the United States Patent and Trademark Office, and I refer to as USPTO, in the last 130 years. The reason it's 130 versus 180 is because the Congress tried 3 times to get a trademark system, and the Supreme Court knocked it down twice and said it wasn't under the Constitution. So they hung it on the Commerce Clause. The patent and copyright systems, by the way, are in the Constitution itself. Article 1, Section 8, Clause 8 of the Constitution of the United States. The number of copyright registrations is closer to infinite for copyright owners, and it's likely around 1 million a week. It's just that there's just so many people that own copyrights, and there's lots and lots and lots of them that are filed for registration. So the numbers there, they don't even keep numbers in copyright because it relates in different numbering systems. So I'd like to refer to some attachments that I have for the trademarks, just to give you an example of how the trademark numbers are speeding up and what goes into a trademark. So here's number 1 million, which was December 1974. And you might recognize it as the Sweet and Low music bar. And the Patent and Trademark Office used to try to choose something that was important, significant, recognizable, or some such. So this was the music bar. They had already registered the words Sweet and Low a full 20 years before that. Now, as a side note, you will notice that this was filed in 1972 in February, so it issued less than 2 years later. The media, which I think was the New York Times at that time, said that, this mark has been in use for a long time, and with bureaucratic delays and so forth, it finally was registered. Total hogwash, typical media crap. If you excuse the expression, that's what it is. They filed it in 1972. Somebody in the legal department at Cumberland Packing said, hey, we got Sweet and Low registered, but we never registered the musical bar. So I said, yeah, why don't we do that? Okay, so they did it. And I can see that happening, and I can almost hear it. I can probably create it just about the way it happened. So that was 1 million. And then 22 years later, we have this one, which was Body Wise. And this is Body Wise International in Tustin, California. It's for traveling handbags and so forth. I don't know what's significant about that one, but it shows you that in 22 years later, we had 2 million, whereas it took, like 80 years to get to the first million. And then we have the 3 million, which is Tot Finder in Alert All Corporation. And that's what's interesting here is that it's printed materials, stickers used at places where children, invalids, and other helpless people may be located in need of assistance. Now, I suppose what you do is that you put a flag that says Tot Finder on top of a stick and wave it when you've fallen and can't get up. I'm not sure. But that's, so that's the next one. Then we have Pocket Socket for wrenches and hand tools. and this was Everhard in Canton, Ohio. And that was interesting in that it was only 9 years later, and it has a disclaimer, which is a technical aspect, but the United States has this system that if you cannot claim rights to the word socket for a socket, which of course you can't, then you can disclaim it. The rest of the world doesn't have disclaimers. I'm not quite sure why ours works so well and they don't have one. But anyway, very few countries have disclaimers. So that's the next one. And then in 6 years, we have the Coastal Taco Bar and Grill from Chagrin Falls, Ohio. And I think people tend to call it Chagrin, but I've heard of Chagrin, so whatever. Restaurant services. And that also has a disclaimer of coastal and taco bar, because you can't claim rights in the word. I'm not quite sure why coastal. They're not really close to the coast, so maybe it's misdescriptive. But taco bar for a restaurant is descriptive and therefore not registrable. So that's perking along here. Now we have 5.5 million, which came up only 2 years later for $500,000. Isthmus. And this points up the difference between foreigners, typically Europeans, and this came from Philip Morris, but in Switzerland. And you see that they list every single thing that's ever passed through the store from the input to the output in the last 10 years, apparently. We don't do that in the United States. We would say, smoking articles, namely something, and you saw the others were quite short. For some reason in Europe, they name every possible thing that is possibly in the store. So that's that one. And then 6 million, which is just a few months ago, just before COVID, NCAP Zing from Ireland. This has several aspects to it, but now you see we're down to 3.7 years from 5 million. By the way, I'm an engineer, and so details are important, but I'm not going to quibble about the dates, whether it's 3 years or 2 years. Give a month or two is okay. This one is 4 different classes, which means it's 4 application fees at the Patent and Trademark Office, and it doesn't have to have use. It's based upon registration in a foreign country under international treaties. By the way, the oldest international treaty in the world relates to patents and trademarks. The Paris Convention from 1873, I think it is. Haven't had to think about it in a while. So that's the oldest active treaty. So, but this is a specific statutory matter, relates to treaties, but was enabled by Congress. So we have for the 4 classes, and they haven't used it yet, but they will have to use it in, by the time this gets to March 3rd, 2026, the 6th year, you have to file a continued use declaration, and that knocks out a lot of the foreigners. But it just is kind of interesting that that it's a very different kind of mark. I don't know why it was chosen to be 6 million, but it is. So we have those, which no, I don't. I'm not. We're going on now. This is a good trademark example. We're going on now to trade secrets because it's very, very recent case of Anthony Lewandowski, who was working for Waymo of Google, and he went over to Uber for their self-driving car unit and took trade secrets with him. He was indicted only last August, and he was ordered to pay $179 million, which is probably unlikely. But then he settled it, Tuesday, last week, a week ago Tuesday. He's going to pay $800 and something million with the 756.5 plus 95. This is how important a trade secret can be. But how unusual it is that it didn't take years. Most trade secret matters do not go to trial for lots of reasons. One is because courts are open and the company doesn't want to disclose the trademark involved to the public. So they'll say, well, okay, we quit, or let's see if we can settle it, or whatever. Or the person, because of a lot of personal stuff that may come out, they settle. So very few trademark cases actually go to judgment. But but this one is so recent, you've probably all read about it, and even if you haven't noted it, you might have read it anyway and said, who cares? So that is an important case because of the fact that it went so quickly, actually. Even though, he only left in August of 16, and come to just, less than 4 years later. And this thing is over, and he's finally agreed. Now, what the bottom line is here, that crime pays, because you got to believe that he has the ability to pay $850 million. $850,000, less than $1 million, because he probably got a lot bigger number than that from Uber when he went over there. By the way, I think Uber fired him, by the way. So those are some of the fun and games that we get involved with. I wasn't involved in that case, by the way, but I read stuff every single day about trademarks, about trade secrets, about patents. Every day, I want to try to keep up with everything. One of the things that will probably come up in some people's minds is that if you work for a company, or if you are a professor at a university and you invent something, who owns it? Good question. Thank you. I'm glad you appreciated that. It's all has to do with contract law. Typically, you work for a company, you sign an agreement that whatever you invent that relates to the company, it's on company time, used company assets, belongs to the company. Now, you may get a bonus for it. That could be cranked into a company's policy. You may or may not. Or you may be able to keep your job, which is always good these days. So the same thing also, but universities are different. For example, a University of California or a California state, they have overriding policies, agreements that you must sign on to. I expect Sam may have signed something, just in case, I don't know. But if you're a research professor, you certainly will be signing things that indicate that you can take it, you can license it, you can own it. Maybe. It depends upon the contract. And it could be very complex. And so then there's another one that is involved in government-sponsored research, which you probably shouldn't get into because, well, it's extremely important. It is what has led to the entire biotech industry by allowing people to have rights in those government-sponsored. If that hadn't been voted in about 40 years ago, we probably wouldn't have a biotech industry. It's that important. So that is, well, I was figuring I'm trying to do it in 20 minutes. I got it done to this point in 16. So here we go. Anybody, any questions?
Thanks, Larry. Yeah, we have a couple questions on the from the cohorts before, and I can post some of those. And I think we have a couple offhand too on chat from Professor Clark. I think one of the questions I got from the cohort, or what we get usually from the cohort, is the fact that when they're doing that kind of website launch, that initial launch of their website, there's going to be some marks there. What does that look like from your point of view when you're giving companies? When should they look at those marks? Should they do the launch? Should they wait? Make sure those marks are registered, things of that nature. I know you had some story, even that story about in Santa Barbara too, but yeah, definitely like get your feedback on that.
Right. That's a very multifaceted. It's about 2 or 3 credits in the university courses to answer that. But anyway, we will go to it. By the way, you know what's interesting? I saw a handwriting on the wall this morning, which was the preservation of health is easier than the cure of the disease. Now that applies directly to, well, lots of legal areas. Now it doesn't apply to family law. It doesn't apply to criminal law because not many criminals are going to ask you before they go rob the bank. But as far as patent, trademark, copyright, trade secret, it's never too early to engage the services of an experienced attorney who knows these areas to find out what can I do, what should I look for, and how should I take care of it. That'll be so much cheaper than trying to straighten it out later. an example from a subtenant of mine a number of years ago had a website developer who was not, let's say, the top type. So he went out and found something that applied from a website of a firm in the Bay Area, and he said, this looks pretty good, and he tossed it in there. So then my friend got a cease and desist letter, and then they filed suit against him. Under copyright law, you have choices of actual damages, which may be hard to prove, or statutory damages, which can be a lot of money. Can be as much as, $5,000, $10,000 per item, per however you might be counted, and that depends upon a judge as to how those are counted. So the numbers can be astounding. He got, so they were claiming copyright statutory damages for copying, and the thing is, it copied. But of course, he tried to implead the website developer, and he's long gone, and he's moved out of state, whatever. So that was useless. And so he decided that he would rather have it done by arbitration. And for some reason, I'm not sure whether he decided, he didn't have me help him. So other than say, what's the situation? That's all. So I'm not quite sure whether he hired anybody or what. But anyway, he got saddled with a large number from an arbitrator who was in Santa Barbara at that time. And it was a shame because, he had nothing to do with it. So the copyright damages are a little bit per or a lot per, depending on whether it's willful or not. And it certainly wasn't willful on his part, but that's what he got saddled with. So you never know. All right, so back to the origin of the question. If you're starting an app, you're starting doing a website or anything else, just please make sure that you're hiring somebody to do it who knows what they're doing. Ask them about where did these images come from. I just launched maybe Monday a new website, and I was questioning him about where did the photo of the skyline of San Diego from Coronado, where did that come from? And he says, well, I think that's blah, blah, blah. So anyway, he went out and made a photo, and then he put that on the website. So that's safe. He did it himself. It may look identical with it, but he did it himself. He didn't copy anybody else's. So it's so important to make sure that whatever you're using when you launch anything is that you are free to use whatever you're using. You've probably heard about the dancing baby thing from about, 6-7 years ago, who was sued for using a song, dancing to a song. It was a silly suit, and I think it was eventually tossed out. But it cost a lot of aggravation for the mother. It was crazy. It doesn't mean that it won't result in a lawsuit, no matter how crazy, because we've got a lot of attorneys around here who need work. So they create things sometimes. And I'm not ashamed to say that. There are a lot of attorneys who create things. And sometimes it's so ridiculous that how can anybody do that? Well, they do. Now, did I get to everything? Trademarks, of course, the same. By the way, I need to mention trademarks. You have rights in the United States from using a trademark. So if you've used a trademark for 10 years in 5 states and never registered it, you own the rights in those 5 states to the trademark, but only to the extent you've used it and for the time you've used it, in a sense. That it gets stronger and stronger the more you use it and the more broadly geographically that you use it. But you can easily, file for federal registration. You get a federal registration that covers the whole country, including Guam and Puerto Rico. So that, it's important that you use it. It's best to use it first, but if you've already, if you're getting something ready to launch something, then have a search done, professional search done to see if the mark is available for your use and registration. It's better to find out up front than it is to get a cease and desist letter after you've built goodwill over a period of 3 to 5 years. So all these things, if they're done early, if you ask the questions early, you can learn enough to maybe sidestep 90, 95, 97% of the possible problem. I think that covered most of it.
No, that was great, Larry, and we have a lot coming in on the chat. Joanna, do you want to unmute yourself for your first question about picking out an intellectual property lawyer?
Now, can you hear me?
Yes.
Okay, perfect. I was just, while you were chatting, I was I was looking up questions that you should ask a intellectual property lawyer if you're thinking about hiring one. And one of the questions was, have you litigated in patent-heavy districts? And I don't even know what the question means.
Okay. Basically, I do not do patent, trademark, copyright litigation.
Ah,
I do prosecution, but litigation heavy may well refer to the Eastern District of Texas and the newly exciting one in Waco, which I'm sure anybody's excited about going to Waco. But at least the Eastern District of Texas is right near Louisiana, so there's something there. The Eastern District of Texas, by the way, and throw in Eastern District of Virginia, they're kind of rocket docket in the sense that they're pretty quick, and they're generally or have been favorable to patent owners, and there's primarily patent matters that go there, not trademark and copyright, although they aren't excluded. It's just there's a whole industry in the Eastern District of Texas, and people have just been going there because they can. And the Supreme Court has said, nah, you can't do that. You've got to go where there's some reason for being there. So they've had a lot of cases that have been transferred to the district where the defendant may well be, or the home office of the plaintiff. And so that may be what somebody's referring to.
okay.
Now,
That's
okay.
Did you want to ask your second question, Joanna?
Sure.
And then
I got a list, but I see Sam was popping in with some too.
Sure.
My second question was, I think that to be an intellectual property attorney, you have some additional education and qualifications that are different than just like a general practice attorney. And I wondered if you could give us some insight about that.
Intellectual property attorney is, I say, patent, trademark, copyright, trade secret. To be a patent attorney, you must pass a patent office bar exam. It has a pass rate now of lower than the state of California. That may be some reason because anybody who thinks they want to do anything will take that, and a lot of them don't pass. And when I was taking it, probably 1/10 of the number of people took it. And the exam was totally different. It was a written exam. Now it's all online and multiple choice. So it's a totally different kind of exam. I'm not sure I could pass it now, but but anyway, to be a trademark, copyright, or trade secret specialist, all you need to do is have a bar in some state.
Oh,
Quite different. And for some reason, the non-patent attorney practice is called soft IP law.
okay.
But I never hear mine referred to as hard IP law, but that's, one of those things.
Even though it might be hard sometimes.
Sometimes, yes. Does that answer your question, Joanna?
Yeah, it does. So it's different to be a patent attorney than an intellectual property attorney.
Well, yeah. But, patents included in intellectual property. But in general, when somebody says I'm an IP attorney, they probably are not a patent attorney.
Okay.
I think Sam definitely had a couple of questions. Sam, I was trying to pick which one. I like the trademark piece, but do you want to unmute yourself for that one?
Oh, I don't know which one you're referring to. Which one was it that you wanted me to ask? I asked six.
Oh yeah, 6. Yeah, whatever you felt was important. I really like the one you said about making a trademark. Does that mark is it also copyright? I was looking at that, but yeah.
So couple. I think questions that could be answered quick. One, if you have a trademark, is it also copyrighted? How do those things potentially work together? Because one's a design, it could be put on a t-shirt, things like that. The other one, so that's one question. Another one that can be quickly answered. If you use a trademark in e-commerce, does it come more broadly protected because e-commerce is not bounded by regions necessarily? People can shop anywhere online. So those are maybe two quicker questions.
Quick, he says. Okay.
Sorry.
All right. Well, let's try the difference between trademark and copyright. If you, let's say that, you have a T-shirt and on the breast pocket, if there's a pocket or that side, you have a logo and maybe the polo pony or something. that is not a trademark use that the Patent and Trademark Office will recognize, even though it's registered. In order to get a trademark registration, for example, on that kind of thing that's primarily a logo and may not even have any words, you have to use it as a trademark, which means as a label and not as a decoration. Decoration is considered descriptive and therefore not registrable. So I always, when people call me the first time, they say, well, I have it on a t-shirt and so forth. I say, well, where does it appear? And they tell me it appears in the back or the front, the left breast pocket area or whatever. And I say, well, okay, now let's not try to register that until you put it on a label. So you can put it on the back of the neck label, where Hanes used to have a label. Now it's all printed. But it's even easier to get one of those little hang tag labels, which is, it's a T-shaped piece of plastic. It goes through a label and you put your trademark on that, and that's usually hanging off the selvage at the bottom of the T-shirt, for example. So you put it on a label and do that, and that's very simple. It doesn't cost much of anything, and that will easily get you qualified to get a registration. Now, as far as a design, the design may well be copyrightable in addition, but that's a totally different law. Copyright gives you the right to copy, and anybody who copies is an infringer. But anybody who has a trademark which is similar may also be an infringer. So there's a difference. The right to copy is indeed a copy. If you, for example, write a poem, and somebody else independently, never saw yours, writes a poem that is, except for a little bit of punctuation and a couple of odd words here and there, is the same, you can both get a copyright on it. One doesn't infringe the other because it wasn't copied. So copyright, it has to do with copying and not with similarity. Trademarks have to do with likelihood of confusion. That is the mark similar enough, and are the products and channels of trade similar enough where the public may be confused? Or is there a likelihood of confusion is the legal test? Actual confusion is just evidence of likelihood of confusion. It's pretty strong evidence, but it is one actual confusion, and that's the only one. You've been in business for 10 years. It's not going to itself carry the day for likelihood of confusion. So does that explain the copyright trademark difference?
Yeah, definitely. It's helpful. I mean, the idea is there's things that are copyrighted. You can't copy a logo, but once that logo is also used to identify a product, then it goes into the trademark stuff. So makes sense.
Yes.
So follow up on that.
The trademark identifies the source of a product. It separates the products from those of others. For example, used to be that you could buy Kenmore washers and dryers and refrigerators and stoves at Sears. I guess you can't buy anything at Sears anymore, but I believe that, they were made by, was it Maytag or somebody for Sears. They may have been identical except for the label and maybe a couple of functions, but those were sold by Sears, and therefore you could only buy them at Sears. And that, of course, as everything changes. So that identified the source, and then the source then is the one who stands behind it. They guarantee it. So, you don't go to the ultimate manufacturer, you go to whoever is selling it. So that's an indication of source of origin is the trademark function. Sorry, I wanted to jump in because that's really important stuff. Go ahead, Sam. What was your second question? Man.
The second question, I mean, is just, I know that when you use a trademark, you kind of get some initial protection. And there's a couple questions that are related to this one. If you're using it in e-commerce, does it become a more broadly protected because e-commerce isn't bounded by like regional, so if you set up a company in California, e-commerce wise, well, it might be easily protected in California, but because you're also selling products everywhere online, does it become more protected elsewhere?
Yeah, that's a very, very good question, and it's not as simple as it sounds. But if you are selling products, we'll start with products, not services. And so you put it on your website. So that's available anywhere, let's say around the world, but at least in the US. you don't have any rights on the trademark for that product until the product with the trademark on it is shipped in interstate commerce. So that's a legal term, sine qua non. It must indeed occur before you can get a registration for a trademark, no matter where you've advertised it. If you haven't ever shipped it in legal, by the way, a bona fide shipment. It can't just go to your cousin in Tulsa. Said, I need to get it across state lines. That's not going to work. That's called fraud. So the e-commerce aspect gets very complex. Patent and Trademark Office people have had a lot of problem with this, and they keep evolving. For services, it's different. So you can indeed get interstate use for your service mark by putting it online, but if you've never provided those services in interstate commerce, then you probably aren't going to get a registration, or not one that'll stand up. It may indeed, you may indeed get a registration because you've alleged certain things in your paperwork, but if you try to sue somebody on it and it turns out that those were lies and you never did provide the services, even in Yuma, then you're going to be holding your hat in your hand. So it gets kind of complex because in order to get the e-commerce, your website, qualify for a service mark registration, you have to have a page that uses the mark in identifying the services, and that you can click on somewhere on that page to order the services. It can't be just an advertisement, okay? Advertising doesn't do it. Business cards don't do it. Letterheads don't do it. You've got to provide the services in interstate commerce or sell the products in interstate commerce. They don't have to sell them, by the way. They must be shipped in a bona fide transaction in interstate commerce. So that can be very complex, and it has been evolving at the Patent and Trademark Office over the last several years, where they have been recognizing things a little differently. It used to be they didn't recognize catalogs for goods. But now, well, I am not comfortable sending something that is maybe a catalog unless there's a picture of the product, like a software box, for example, when maybe software is actually shipped. A picture of the box showing the trademark on it. I'm comfortable with that, but I'm not comfortable with just telling about the thing and you can't click on it to order it. So there's a lot of complexities there that and they are changing. Does that get you answered?
Thanks. Yes. Thanks, Larry.
That was great, Larry. I know Stephen, I know we had some pretty good questions too. I know you had some other ones. You want to pose any questions, guys?
You asking me?
Oh yeah, I got it. If you had any questions.
Yeah, Larry, I got a question for you. So this is a question that we've come across a number of times, especially with early stage startups. So the question is, I guess, how do you, or I guess what approach would you take to keep your intellectual property safe during those initial discussions as a startup? So during the early stages, startups may have to discuss, their business plan or give away details about, their IP to get feedback from people like advisors, prospective customers, attract investors, or a number of situations like that, right? So what approach would you advise, these startups to take when they want to, because they want to be able to protect their ideas, even though they have to have these, public, quote unquote discussions as an early stage startup?
Yeah, that's good. It's also multifaceted. Back to the quote that I gave you from Off the Wall this morning. It's never too early if you're thinking about starting something. That's a new product, a new business, an app, a service, or whatever it might be. It's never too early to talk to an IP attorney and find out what you need to make sure that you don't do wrong, as opposed to what you should do right. Because it costs, well, as this thing said, it's easier to do it up front right than it is to cure it later. So that would be the place to start with an attorney who knows what he's talking about and has at least some experience. in trademark, copyright, and trade secret certainly too. Law, even if it's not a, you may not have a patentable type of product. It may be a new service, but you start there, and you can find out all the things for a few hundred or a few $1,000s, where it might cost you hundreds of thousands of dollars later when somebody says, you're infringing my trademark, or you've copied my some of my copyrighted material. So if you start there, you get the instructions on what to do and what not to do, and that's really so important. And most people don't do that, so they hope that they skate properly on heavy ice before they get to the thin ice, and they eventually find out what they need to know without having to pay somebody a lot of money. And like the other guy who says, you owe me hundreds of thousands of dollars for these infringements. Okay, that was part of it. Now, I got involved in that, so tell me what the other part of it was.
So the other part of it is, if you, as an early stage startup, want to have discussions with.
Yes, got it.
Yeah.
Okay, yes. We use a confidential disclosure agreement, which is commonly referred to as an NDA, which is a non-disclosure agreement. Very simple, 2 or 3 page, short, a simple agreement. You are disclosing information, it may be some details, to somebody because you need their expertise or their money. For example, you go to a source of money, or maybe a angel investor, it may even be a bank or whatever, and you need a loan for whatever, and they say, well, maybe we will take property rights in what you're doing. You say, well, okay, I can't disclose it to you until you sign this agreement that you're not going to use my information nor disclose it to any third parties. And that's what an NDA is all about. So you can, if you're making a product, you might want to go to a metal bending shop or a carpenter shop or whatever it might be to get something made, plastic molding or something like that. And they're obviously going to have to know what it is you're making. So that would be where you would want to use an NDA. And people like that who are providing a service, they're getting paid for providing the service. They're not interested generally in ripping you off. But if you have the agreement, you've made it clear up front, and they know that you are sensible enough to take your rights seriously, and to let them know that you take your rights seriously. Therefore, by signing the contract, they are on notice, and almost never are those things enforced because they don't have to be. People know that they've signed an agreement, it's a contract, and it's enforceable. So it typically is, it really does what it is that you asked, and that is how can you be sure? And I get people all the time who don't want to tell me anything about, but they want to ask me, about a patent matter or something, but they don't want to tell me anything. I said, well, look, my license is on the line. I have to maintain your information in confidence. I lose my license if I don't. I don't think that yours, nor has anybody else in the last 50 years been worth my license to get rid of, to steal your invention, and it never will be. So that's, for attorneys, they are under an obligation of confidentiality under the rules and the laws and everything else that govern the right to practice law. Did that fully answer your question?
Yeah, definitely. Thank you, Larry.
Good.
Larry, I had one more, I would say an easy question, but difference between a word mark and a style mark, and is one better than the other to have?
Yeah, okay. That one is actually almost easy. Look at Coca-Cola or Pepsi-Cola. Those are not just plain block letter marks. They're a logo with words, or words with logo, whatever. So probably 60% of trademarks are merely letters, words, numerals, and don't have any style to them. And maybe 40% have some kind of a logo aspect. Typically, there are words or letters that are maybe pronounceable involved with it, but so it's not a better or not better. The question is, what is your trademark? And if your trademark is a stylized version of, the word Polaroid, for example, or Texaco or something like that. It's a stylized version, and that's the way you always use it, then register it that way. But if you use it in plain block letters as well as in the big sign has a stylized version, then register both ways, because you want to get the broadest protection is for plain block letters, and black and white. You may change colors as you go along, but a logo is very often involved, but it doesn't stand on its own. Now let's go back to the polo, for example. The riding polo, the polo player on a horse. That is registrable just as simply as a logo, because everybody recognizes that. But it's also the word polo is involved. So maybe their trademarks, what they use the pony and the polo together. So you get 3 trademarks. You've got the logo, you've got the word, and you've got the two things together for your 3rd trademark. So there's not a better or worse or stronger or better. It's a question of what do you use and what do people recognize. And I've had discussions with clients over the years about how they use it, and do you ever use this combination? Do you ever use them separately, the logo and the words? And if you use them separately, then probably should register it, all 3, but generally the words are more important, because that's the thing that somebody can spell, can say, and refer to others about.
Thank you.
That was great, Larry. I'm thinking at this time we'll wrap it up too. But Larry, I always say thanks for your service, and always just in general, just for your support for all the startups over these years. So I always appreciate your candor and how you are with all the startups. Definitely, I feel like this national treasure for startups and businesses. I thank you for that. I was going to ask to Sam, do you want to add any aspects of what the innovation challenge was? Do you want to get a little synopsis of what just happened, and then I'll let Stephen round it up with that.
I think if I heard you correctly, Curling, you just wanted me to say a couple things about what we did with the Innovation Hub. So we're just wrapping up Summer Innovation Challenge, and we'll be kind of letting people know about the winners of that competition. And this fall, we'll be moving into our Fall Innovation Challenge. So what that is basically we look at some societal needs or needs in the communities in which we are at. We live, and then put the students at CSUM to work on trying to come up with some ideas to solve those needs. So the Summer Innovation Challenge focused on K through 12 schools and how can we help them either improve distance learning or get back onto campus with kids in the classrooms, and there's lots of challenges that teachers, parents, administrators, students face. And so that was the goal, was to come up with ideas to better serve it. Those in need. And this fall we'll be doing something very similar. So look for that information as it comes out. We'll be posting information about the next challenge, and hopefully you can participate. And there's a chance to win some money, which is also nice as students. So anyway, that's what we're working on, and hopefully you join us. And I'll let Stephen wrap everything up.
I have a question. Is this recorded? And if so, can anybody access it?
Yeah, it's recorded.
And is it accessible so that I could have my office staff look at it?
Yeah, sure. Yeah, we can send you a copy if you like.
Okay. Thank you.
And your technical assistant?
Yeah, without her, none of this is possible.
Well, thank you. And thank you to your technical assistant. We appreciated having you on today. It was great.
I appreciate it, and it's been a pleasure. I enjoy, it may come through that I enjoy talking about these areas of law.
Yeah. Well, we always love having you. So thanks again.
How you doing now?
All right, well, I'll wrap it up then. Thank you, Larry. Just to kind of echo what Joanna just said, thanks for coming on. I know we always enjoy talking to you, And we're glad that, we had the opportunity today to, have some questions answered and, share some of this information for startups out there. Because I know that, intellectual property is a big topic, especially for small businesses, startups, and there's a lot of entrepreneurs that kind of want to know what direction to go with a lot of these things. So thanks for sharing your knowledge and insight today.
You're very welcome.
All right. Well, I'm going to wrap it up. So thanks, guys, for tuning in for another episode of Tech School. Just a reminder, just to kind of echo what was said in at the beginning of the show. If you guys have a chance, feel free to like, comment, subscribe on our videos on YouTube when we get this posted. Any interaction that we get improves the reach for those videos. So that like or that comment that you leave might push that video out to an entrepreneur that really needs it. So we appreciate any sort of support that we can get to help support the community with videos like this. So thank you, guys. Take care.